Vijay sir, you can start.
Yes, madam. Good evening, everyone. Distinguished resource persons of the day, Professor Dr. Anis V. Pillai, Associate Professor, School of Legal Studies, Cochin University of Science and Technology. Respected Principal Sir, my esteemed colleagues and dear participants. This is Dr. Vijay A. N, Assistant Professor and Coordinator of the present FDP program. It is my privilege to welcome you all to the Day 3 of 7-day Faculty Development Program on New Labor Codes. Today we have with us a distinguished resource person, Dr. Anis Pillai, Associate Professor, Cochin University of Science and Technology. It is my honor to present a brief profile to you all. Dr. Anis V. Pillai is an Associate Professor at the School of Legal Studies, Cochin University of Science and Technology, Kerala. He is also holding a position of Coordinator, Justice V.R. Krishna Iyer, Chair on Human Rights, Cochin University of Science and Technology, Kerala. Before his tenure at the university, Dr. Pillai held a faculty position in Hidayatullah National Law University, Raipur, Chhattisgarh. His academic excellence has been recognized with prestigious award, including the Distinguished Young Faculty Award for the academic year 2017 and 18 from the university. He has also been honored with the Professor Dr. A.T. Marcos Memorial Gold Medal for securing the first rank in LLM, alongside the K.C. Menon Memorial Gold Medal for being the best student in LLM from the university. He was awarded a postdoctoral fellowship from the Mediterranean International Center for Human Rights Research, Italy, and in 2023. He was the recipient of the Insight 2023 fellowship at the India School of Internet Governance. He has also served the position of visiting professor at the Department of Law, Dhaka International University, Bangladesh, and coordinator Virtual Center for Research and Humanities and Social Science. He has also developed a mock course on consumer protection laws, which is successfully offering as a 4-credit course to interested students. Dr. Anis V. Pillai has made a notable contribution to legal scholarship through his authorship and editorial work. His notable authored books include Surrogate Motherhood and the Law, the NDPS Act 1985, Artificial Intelligence and Legal Innovations, the State Responsibility under International Law, etc. In addition, he has served as a editor for several scholarly volumes such as Short Notes on Computation Law in India, Cyber Laws, Issues and Concern, Shaded Justice and Rights, Secularism and Freedom of Religion, and Climate Change Laws, Issues and Perspective. Among other, his scholarly activities extended to participation in numerous national and international conference, workshop, and training programs. Notable among these, this is the IUCN funded Train the Trainers program in Colombo, Sri Lanka. The international conference at Dhaka International University, Bangladesh, and the International Summer School jointly organized by Bachesher, Cyprus University, and University of Sarjavia and Pramink, Associate Sarajevo, Turkey, etc. He has also engaged in workshops and conferences across the globe, including in the Netherlands, Israel, the USA, South Africa, Vietnam, Taiwan, Brazil, Singapore, Bangladesh, Indonesia, Sri Lanka, and more. In addition to his academic and research contribution, Dr. Pillai has rich experience in adjudicating national and international moot court competitions, such as the Stetton's International Environmental Moot Court Competition, Philips A. Jessup International Law Moot Court Competition, and the International Criminal Court of Court computations, etc. He has also crafted moot court problems in areas such as competition law, consumer law, international law, environmental law, and human rights for various national and national level competition in India. Sir has accepted our invitation and agreed to deliver a lecture on statutory bonus under India's new labor codes, key changes and emerging challenges. So, on behalf of the Janata Educational Society and Vivekananda College of Law, and on behalf of my dear participants, I extend a warm welcome you, sir.
Thank you. Thank you
And,
so much.
And also, I take this opportunity to welcome our beloved principal, Dr. K.P. Gempagoda, sir, on this occasion. And also, I welcome my dear esteemed colleagues and dear participant on this occasion. Over to you, sir.
Thank you. Thank you so much. Am I audible?
Yes, sir, you are audible.
Okay. So at the outset, let me thank your principal, Professor Dr. Kembagowda sir, for giving me this wonderful opportunity. Dear friends, today I will be speaking about bonus, the statutory right to receive bonus, and the calculation, etc. What are the changes introduced by the new wage code? And as well as what are the challenges which we expect when we introduced a new wage code by abolishing our Payment of Bonus Act. Well, as an introduction, my screen is moving. It's moved, right?
Yes, sir. Yes, sir. It's
Okay.
moving.
So, as an introduction, let me tell you what is bonus. Now, everybody know there are large scale workers in our country, large number of workers in our country in different sectors. Now, when an employee working in an establishment, it is like employee receives salary or wages and employer earns profit out of it. All the businesses, whatever be the businesses, it is running for a profit. Otherwise, it's a charitable institution. Now, when an employer generate huge profit or a profit which is more than what they are expecting or what they are required, sometimes this employer will share a portion of that profit with the employees. Now, bonus is an additional payment in addition to the salary from where they are paying from the profits. So, in simple words, we can say bonus is a part of the employer's profit which is being shared with the employees. Because the reason for that profit is hard work of the employees. And in India, we have a strong legislative framework to deal with issues and concerns relating to payment of bonus. That is what our Payment of Bonus Act 1965. And recently, since we have made a sea change in our labor and industrial law, along with other legislations, our government has repealed Payment of Bonus Act and the provisions relating to payment of bonus now is placed under the wage code. So we will discuss in due course the provisions in the wage code. Before that, let me explain little bit further about bonus. Now, as I said, bonus is an additional payment or something which is extra to the wages. Why an employer is paying or sharing profits of his company with his employees? There are many justifications, many reasons. First of all, we can say there are some economic reasons. If you analyze in a jurisprudential way, you can find certain economic reasons. What are the economic reasons for paying bonus? First reason is employees are contributing or it is the hard work of the employees. That is why the profits are generating. So there is a moral responsibility vested with the employer to share a portion of that profit with the employees. Secondly, when an employee receives a payment in addition to the wages, the prescribed wages, it will encourage the employee to put more effort, to work more effectively, because the employee knows if he works hard, if the company gets more profit, he is going to get more share. So it will encourage greater efficiency and that will lead to productivity. So that is another economic justification. Then the commitment. When employees are well paid, well received a due share from the profit, they will become more committed to their organization. So these are the economic reasons behind payment of bonus. Now, there are certain social conditions also, or social reasons also. One of the social reason is improvement of living standards of workmen. Now, we all know there are large number of workers in our country and their wage structure is different. Some are working in a very low and some middle, like that. Now, because of many reasons, employers are not in a position to pay for all the employees equal wage structure. So, when they are allowed to pay a part of their share of profit, the employees are the beneficiary. That will directly lead to improvement of their living standards as well as their families. So that is another social reason. Then reducing economic inequality. As I said, whatever be the wage structure, when they are getting something in addition to that, they will be economically more better position. Then equitable distribution of wealth. Rather than concentrating all the wealth with one or two or three or few business houses, if the profits are being shared, it will be equitably distribution of wealth. So that is another social reason. And there are industrial reasons also behind payment of bonus. As I said earlier, when bonus is being given, the employer-employee relationship will become more stronger because the employees will feel a sense of belongingness. He will do his work with more strength, more sincerity. Then it will reduce automatically when the employer-employee relationship are in a very cordial manner. Then it will automatically lead to reduction of unrest in the employment or the industry, and thereby it will reduce strikes, industrial disputes, lockouts, etc., etc. Then it will create a sense of belongingness among workers. Now, there is a legal reason also, or there are two legal reasons also why we are paying bonus. After 1956, especially after the adoption of our Payment of Bonus Act, payment of bonus is made as a statutory right. So, right to bonus is also created. So, that is another reason at present for paying bonus. Then automatically, when these type of additional payments are being given, it will support our constitutional goal of social and economic justice. So these are the justifications for providing bonus in our country. Well, there are many theoretical foundations behind the payment of bonus. I'm not explaining in detail, but as a student or as a faculty, we need to know what are the theoretical foundations behind payment of bonus or right to bonus. The first theory is gift theory. Second is deferred wage theory. Third is profit sharing theory. Then fourth one is social justice theory. And finally, productivity theory. So these are the theoretical foundations behind our bonus legislations or right to bonus. Well, in our country, through customary practice as well as industrial practices, we have classified bonus into different category, or there were different classifications of bonus. Though the act does not spells out all these category, but from the practice of industries or employers across the country, we can say there are different types of bonus available in our country. The first type is statutory bonus. No doubt, it is a bonus which is being given as per the provisions of Payment of Bonus Act 1965. Second is ex gratia bonus. It is a bonus paid by the employer as a gesture of goodwill in addition to the above statutory bonus. So when an employer gives an amount in addition to the statutory fixed amount as bonus, that is ex gratia bonus. Then performance bonus, that is another category. A bonus paid to the employees based on their individual performances Usually nowadays it is applicable in IT sector and in certain insurance sector and everything. Based on the monthly performance or target achievement, they will get some bonus. Then festival bonus. We all know the bonus like a puja bonus, Diwali bonus, etc. During festival, to meet the expenses of that festival, during the occasion of festival, the employer will give a bonus. That is what is known as festival bonus. Then profit sharing bonus. This is a bonus paid to employees as a share of the profit earned by the organization. This is usually calculated based on the percentage of the employee's annual salary or wages. This is again, it is not in accordance with what is we are calling it as statutory bonus. It is over and above to the statutory bonus. Then retention bonus. This is a bonus paid to employees to retain them in the organization. Usually, this is happening in some IT sector and hospitals, where doctors will express their intention to leave from that place. Then immediately they will be offered a good amount so that they will remain there. They will not shift from their workplace to another workplace. So these are the different types of bonus which is prevalent in our country. Now, if you look at the history and evolution of bonus, there's a very small history. Just in few minutes, I'll tell you how the idea of bonus evolved. Now, this practice, the practice of paying bonus, is rooted in ancient kingship. There are ancient kings as well as rulers. They used to reward soldiers and workers with extra payments as well as gift. And this practice is considered as the beginning of payment of bonus. But interestingly, at that time, these gift, extra payments, etc., were voluntary in nature. It was not mandatory or there were no right to receive as such. It is completely left to the discretion of the king and rulers. Then in the medieval period, there started guild and organizations or professional organizations. Then they also started giving profit, sharing of profit occasionally. And during festival season, they started giving some extra payment. Or sometimes when they are in trouble, they started giving some extra payment. So this was the practice during medieval period. Thereafter, we have seen industrial revolution. When industrial revolution happened, this factory owners, they started accumulating profit because of the introduction of mechanization or use of machines. When they started earning huge amount of profits as a voluntary mechanism to attract, to repose confidence on employees, these factory owners started paying small amounts in addition to salary. So this is the exact beginning point of payment of wages. We don't know in which year it started, but the factory system, especially industrial revolution, is the reason for the beginning of payment of bonus system. Then the after this industrial revolution, slowly our labor movements become very strong. Trade unionism started. So once labor union and trade unionism started, they started demanding it. And some companies paying the profit, sharing the profit as bonus, and some companies are not willing to pay. So there started some sort of dispute. And finally, that resulted in adopting a legal framework in most of the country to regulate payment of bonus. So this way, the idea of statutory bonus evolved in the world. Now, this person, Edme Jean Lacary, he is considered as one of the person who started the idea of paying this particular bonus. And he was a French entrepreneur. Now, in India, if you look at Indian scenario, during First World War, we had many textile mills. They started paying an extra amount to workers in the name of war bonus. And especially textile mills situated in Bombay and Ahmedabad, they were the leaders in developing the mechanism of payment of bonus. And slowly, when this labor movement started, especially trade unionism developed in our country, they started demanding profit and they started interfering with wherever there is a dispute regarding bonus payment and everything. And in the meantime, there was many cases which reached to the judiciary also. So Indian judiciary also interfered with the bonus related disputes, and they have established many principles dealing with settlement of bonus, payment of determination and payment of bonus. So this way, in India, the system of bonus developed. Now, one most important development in Indian context is the fixation of full bench formula in 1950. This was actually developed by Labor Appellate Tribunal as well as our judiciary through different cases. During 1950s, there were large-scale disputes regarding payment of bonus. So what these judicial bodies did, they have created a formula for determining the quantum of bonus. And based on each worker's wages, they have fixed a criteria to determine the bonus. And that is popularly known as full bench formula. This was happened during 1950s. And even after this full bench formula, there were many disputes regarding the calculation of payment and calculation of bonus and payment of bonus. So what Indian government did, they have appointed a bonus commission in 1961. This commission undertaken a detailed study regarding the structure of bonus, the payment of bonus, need for bonus, and the criteria to fix bonus, everything. And finally, they recommended making a law dealing with all these things. So, as a result of the recommendations of Bonus Commission in 1961, we have adopted our Payment of Bonus Act in 1965. Now, when this Payment of Bonus Act was introduced in 1965, it had many objectives. The major objective is, as I said, to provide a statutory framework dealing with payment of bonus in our country, and that to establish a uniform principles throughout the India. So this was the major objective of Payment of Bonus Act 1965. And this act was continued for a long time, and this act was made applicable to each and every factory in our country, and all other establishments where 20 or more persons were employed. And in the meantime, there are many state governments, that is appropriate governments, they had given the liberty to include any establishment, even if it is below 20 or more persons, they can bring that establishments under the purview of this act. So this act was functioning well. In between, there were many disputes. Even there was a case which challenged the constitutionality of payment of bonus as such, or imposing an obligation to the employer to pay bonus. So all those cases were decided, and this law continued for a long time. And this is one such case where the constitutional validity of imposing a statutory obligation to pay bonus was fixed. Now, in this case, the court said, or the Supreme Court upheld the provision which mandates statutory payment of bonus. Though it has struck down three provisions in the Bonus Act, but the major obligation, that is payment of statutory bonus, that was held constitutional. I'll just quote the wordings of the court. The court said the object of the act is to secure to the employees a fair share in the profits of the concern, and thus to promote industrial peace and harmony. And this this act is a social welfare measure aimed at securing industrial peace and providing a fair wage. Thus, the court said the provision which mandates statutory payment of bonus is constitutional. So this is one of the very important case. Those who want to know more, please read this case. You will get a clear picture about why we introduced Bonus Act and why it should be considered as a constitutional legislation. Everything you will get. Now, if you look at other countries' scenario, there are many countries like India, they are following a bonus system. You can see Japan, United States, United Kingdom, France, Germany, China, all these countries having a system somewhat similar to us. So if you are interested to make a comparative study, you can read these countries' perspective. Well, our Payment of Bonus Act 1965, it continued. Many employees received the benefits. But finally, when it comes to 2015 to 2019, there were large scale changes introduced or reforms introduced in our labor and industrial laws in the country. So, as a result, the entire Payment of Bonus Act 1965 was repealed and thereby introduced Chapter 4 in the Code on Wages or Wage Code 2019. Now, sections 26 to 42, Chapter 4, sections 26 to 42 of Code on Wages dealing with bonus, the statutory bonus. So, this was received presidential assent in 2019 and it was notified in 2025. November 21, 2025, the provisions relating to bonus was codified. But it is not yet functional, in fact. Even though it is notified in November 21st, in 2025, it is not yet came into force because every state government has to create rules in their state. So that is not yet happened. So technically saying these provisions are came into force, but practically it is not applicable now. Even the old 1965 Act still continues. So that is the present legal position. But since it is replaced with the wage code, I will be speaking only on the premise of wage code. Now, after that, I will make a comparative study with 1965 to wage code. Now, starting with eligibility of bonus. As of now, as per the wage code, who all are entitled to receive bonus? Section 26 very specifically says the eligibility criteria. Now, the first point is every employee drawing wages not exceeding such amount per mensum as determined by notification by the appropriate government is eligible. Now, the interesting thing, if you look at 1965 Act, the amount was 21,000. But now, I think many of the appropriate governments are not yet fixed the amount. So, in the absence of fixing the amount, who will come under this? I don't know. See, frankly speaking, I don't have an answer. But as and when the appropriate government notifies what is the wage, then all such employees will come under the purview. That is the first criteria. Second criteria is those employees should put in at least 30 days work in an accounting year. So whoever, say for example, it is 21,000, just assume 21,000. If the wage is 21,000, then they should work at least 30 days in an accounting year. This is the criteria. So those employees who satisfies the wage ceiling plus works more than 30 days in a year is entitled to receive bonus. That is the eligibility criteria. Now, there are many things regarding calculating the ceiling limit. Only after fixing this amount, we could do further analysis on that. But as of now, you should understand there is a wage ceiling that should be prescribed by the appropriate government. Then, if it is a new establishment, this is one of the new thing which is not there in the old act. If suppose I am starting an establishment in 2026, I am not supposed to pay bonus till I will complete 5 years. So as far as a new establishment is concerned, they are exempted from statutory payment of bonus for a period of 5 years. So only after 5 year or 6th year onwards, they are supposed to pay the bonus. So this is what eligibility for bonus section 26. Then who is not covered or who is not eligible to The Act specifically says who is not eligible to receive bonus. Now, very interestingly, those establishments where 20 or less people, less than 20 employees are there, they are not eligible for bonus. So your establishment must have more than 20 employees. Now again, here also you can find a difference with the old law. In the old law, the appropriate government was given a discretion to bring any establishment, even if it is not satisfying 20 employees criteria. The appropriate government can bring them under the provisions of this act. But now the wage code does not provide that liberty to the appropriate government. Now, specifically, the act excludes employees of LIC, RBI, and other public sector financial institutions specified by the government. They are not covered under this act. Then those employees covered under Seamen Merchant Shipping Act, they are also excluded. Then employees of government and local authority departments, they are also exempted. Then employees of institutions established not for profit, like universities, hospitals, chamber of commerce, essentially speaking, service-oriented agencies or institutions. So these are the persons or employees. They are not eligible for bonus. Now, minimum and maximum of bonus. Section 26 again talks about the minimum bonus. As per the Act, every employee should get a minimum bonus. The minimum bonus should be 8.33% of their wage. Say, for example, if their salary is 100, then they should get 8.33 rupees. Suppose if their salary is 1000, they should get 83.3. But the Act provides a minimum amount, that is 100. So that means whatever be the salary, they should get either 8.33% of their wage or 100 rupees, whichever is higher. Whichever is higher. So this is the minimum bonus, statutory minimum payment. And interestingly, the Act prescribes maximum bonus also. In any case, maximum bonus should not exceed more than 20% of their wages. More than 20% of their wages. So the minimum bonus is 8.33% of their wage and maximum is 20% of their wages. Then, how to calculate bonus? This is one of the very challenging topic or challenging area. There were many cases, many disputes under the erstwhile Bonus Act. But when it comes to new wage code, it simplifies the process of calculation of bonus. So very simple. I'll tell you in very simple way how to calculate bonus the bonus amount in a company. Now, every calculation, the payment of bonus is directly depend on surplus. So that terminology you need to understand. Surplus. That is, the payment of bonus is directly linked with availability of surplus. Okay. Now, what is this surplus? Sections 31 to 34 provides the rule to determine or calculate available surplus. Now, first point is gross profit of the establishment has to be calculated. Gross profit. Section 32 of the code provides the central government can prescribe the rules to calculate gross profit of an establishment. So once gross profit of the establishment should be calculated. That is the first step. Now the calculation method, calculation criteria will be prescribed by the central government. Now based on those criteria, it is identified what is the gross profit. We got a figure. Now, from the gross profit, we have to deduct various charges that is prescribed in section 34. So whatever amount we are deducting from, whatever amount left after deducting the permissible deductions from the gross profit, we will call it as available surplus. So available surplus is equal to, or surplus is equal to gross profits minus deductions. This is the simple formula. So just remember, gross profits minus permissible deductions is equal to surplus. Clear? Okay, that is a very simple mathematics. Now, once you identified the available surplus or surplus, you cannot pay entire surplus as a bonus. A company is not supposed to pay entire surplus as a bonus. Now, the law prescribes a prescribed percentage, that is, from the available surplus. If it is a banking company, only 60% of the amount can be disbursed as a bonus. Suppose a company's gross profit is 10,000 and the permissible deduction is 2,000. So available surplus is 8,000. Now among 8,000, only 60% can be utilized for paying bonus. Not more than 60% if it is a banking company. Now if it is other establishments, they can spend up to 60% of the available surplus for paying bonus. So this way, the total amount will be calculated. That is, available surplus will be calculated. From the available surplus, now we are going to give bonus to each employees. Clear? So the first step is determining the available surplus. That is identifying the 67% of the available surplus in other establishments and 60% in the banking company. So once it is identified, okay, this much amount can be distributed as bonus. Then we will take one by one employee and determine how much amount each employee will get. So this is the way calculation will proceed. So as a first step, we have determined what is available surplus. That figure we got. Now coming to set off and set on mechanism. Section 36 deals with set off and set on mechanism. That is, every year profit may vary. Some year they will have good profit, some year they will go in loss. So they may not be able to pay the required bonus, or sometimes they may be deficient, sometimes they may give more. So this, from the available surplus, they can do this set off and set on based on the variation in the previous years. So that is what is the provisions of set off and set on. Like when we borrow money from somebody and subsequently when we repay, we will also do this set off and set on. So likewise, the employees can arrange their available surplus for the purpose of this set off and set on. Now, after making all these set off and set on adjustment, whatever surplus amount is remaining, that is what is amount available for distribution as bonus. I hope that is clear. So first we determine the surplus amount, available amount, that is gross profit minus permissible deductions. Then the required percentage, that is the surplus amount available for bonus. From the surplus amount available for payment of bonus, we will do set off and set on based on the previous history. Then we will take giving payment to an individual employee. We got a figure. Now, assume an employee receives monthly salary of 50,000. Now, as per the Act, he should be paid a minimum of 8.33%. That is 8.33% of his total salary should be given as bonus. And maximum can be 20% of his total salary. So this is the statutory minimum and maximum. Now, let us assume an employee who is having 50,000 as the salary. How we can pay or how much he will get bonus. Now, when you calculate the salary, we have to compartmentalize salary into based on the components. Like every salary will consist of different components. Basic pay will be there, DA will be there, HRA will be there, other allowances will be there. Many allowances will be there. So, the total amount is the salary. That is a 50,000 in our case. Now, in this total salary, 50% of the salary should be calculated first. That is 25,000. In that 25,000, we have to see how much is the basic pay plus DA. That is 20. So, the remaining 30,000 is other allowances. Now, we have to calculate the difference between excluded allowances and basic plus DA. So here the basic plus DA is 20,000, excluded allowances is 30,000. So the differences is 5,000. Now the statutory wage for providing bonus is 50% of his, sorry, the statutory wages, statutory payment for the bonuses, wage for determining the bonuses, basic plus DA plus excess allowance. Excess allowance we have identified 5,000 only. So the basic plus DA for him is 20,000 and excess allowance he was receiving is 5,000. So his salary, his wage for determining the payment of bonus is 25,000. Now he is entitled to get 8.33% of 25,000 as the bonus. This is the calculation. I hope that is clear. If you have any doubts now, you can please raise, because this is something very complicated if you are listening first time. So if you have any doubts, we can discuss now only regarding this calculation. Other points we will discuss further. Anybody?
Sir, I have a clarification, sir.
Yes, please.
Sir, bonus to be determined not on 25,000, sir. It is the bonus. Bonus wage is not 25,000.
Okay.
Actually, that amount should be notified by the appropriate government.
No. This is only an illustration I am giving.
Yeah.
That's what I said.
That amount, the Act says that amount or minimum wages, whichever is higher.
Correct. That is true. So earlier it was 21,000. Now I just gave an illustration. As and when the central government or appropriate government notifies the wage, then that wage will be the criteria. Clear? Okay. So that is the thing. So this is the minimum calculation. Now this is only for the purpose of illustration purpose I am making. But once the government prescribes the amount, then that will be the salary for the wage for determining the bonus. So into 8.33 will be the salary. And in our case, if 25,000 is the salary or wage for the bonus, then 25,000 into 8.33, that will come around 2,082. And if the employer is giving maximum 20% of the bonus, then 25,000 into 20, that will come around 5,000 rupees. So this way, the determination of maximum and minimum wages will be done. And this amount will be done based on the available surplus. Suppose the 67% available surplus dedicated for paying the bonus, that is earmarked. Now, out of that 67%, all the employees' eligibility will be calculated, and based on the available 67%, the employer will decide either 8.33 or 9, 10 or sometimes up to 20%. So it all depends upon how much available surplus is there for disbursing as bonus. So based on the wage salary, everything will be determined. And while determining, what is the exact percentage of bonus in a year? That will be determined based on the figure in the available surplus. So that is what the calculation of bonus. Now, there are certain provisions regarding the time limit or when to pay this bonus. What are the methods to pay bonus? Everything is specifically mentioned in the code. Sections 37 to 40 very specifically says when to pay this and how to pay this bonus. Now, the act says bonus must be paid by crediting it to the bank account. Now, interestingly, you can see a difference with old regime. In old regime, bonus should be given in cash. It should be paid only in cash, no other way. But now it is allowed to deposit in the bank. Then every year, within 8 months from the close of the accounting year, the payment should be done. Now, the period can be extended by the government upon application. That is when to pay this bonus. And in case of any dispute regarding the payment of bonus or rate and everything, at the earliest, a minimum should be paid. That is, minimum 8.3 should be paid. Then, based on the outcome of the dispute, whatever higher rate is available, that can be done. Now, initially I said there are different classification of bonus. Then I said there is something known as customary bonus. Now, in many parts of our country, many establishment follows payment of customary bonus. Now, if you have paid customary bonus like a puja bonus or Diwali bonus, that can be adjusted with the duty of paying statutory bonus. So that adjustment is also permitted. So this is what the rules regarding the timing and adjustment of payment. Then under section 29, specifically the bonus act says an employee is not entitled to receive or there are certain disqualifications for an employee from receiving bonus. And this was there in the older regime also. But there is an interesting new introduction in this provision. Earlier it was there like fraud, righteous or violent behavior while on the establishment premises, theft, misappropriation, sabotage of any property of the establishment. All this was there in the old regime also. When an employee is indulging in this type of activity, he will be disqualified from receiving the bonus. Now the new wage code introduces a provision, conviction for sexual harassment. So if an employee is convicted for sexual harassment at workplace, then he is not eligible to receive any bonus. So this is a new provision introduced in the code. So these are the disqualification from receiving bonus. Now, so these are the provisions under the wage code dealing with bonus. So essentially, it talks about eligibility, calculation, disqualification, and payment, etc. These are the major provisions. Now, let us make a comparison between the Bonus Act, our old regime, and the new regime. Now, old regime, as I said, there was after the latest amendment, the wage was increased up to 21,000 per month for the purpose of determining bonus. But as of now, in the new act, the appropriate government will notify. It is not yet notified. Then calculation. In the old regime, it was defined in a specifically, there was a specific criteria for calculating the wage. And interestingly, at that time, we had many legislations and all these legislations having different definitions for wage. So that wage calculation was a challenging problem at that time. Now, when it comes to new code, it has introduced a unified definition for wage. So all these aspects of determination of bonus will be based on this wage, whichever be the sector, whichever be the law, whatever is the provision, this wage definition uniformly applicable so that the determination will be very easy. And one interesting thing was done, especially in certain companies. There was a bad practice. They'll prescribe salary and everything, and the salary or wage structure will be very less in order to evade certain statutory obligation, and they will give more allowances than wages. Now, the interesting thing, if they add wage in that way, the wage will increase and automatically many legislation will apply, many provisions will apply, many statutory obligations will come. So, to avoid that, they will keep wage in a less manner, like basic pay and HRA will be very less, but other allowances will be more. Now, what this court did to prevent those type of malpractices, what this court did, they said if any establishment giving more than 50% of the wage as the more than 50% as the allowances, that will be considered as wage. So suppose your basic is only 20,000, but your allowances is 18,000 or to 11,000. That whatever amount is there more than 50%, that percentage will be counted along with your wage, so that your wage will be more. So that benefit will come. So that is another change introduced in the new code. Then allocable surplus, the entire amount from which is dedicated for paying bonus is the available surplus. Under the old regime, it was 60%. Now, except for banking companies, that available surplus percentage is increased up to 67%. So 67% is the available surplus now for disbursement or for providing bonus. That is another new change. Then regarding disqualification, as I said, earlier also we had many disqualifications, but interestingly, conviction for sexual harassment. Now this conviction for sexual harassment, everybody know, we have a legislation that is POSH. Now under the POSH Act, there will be internal complaints committee in every establishment. So whenever an employee commits a sexual harassment as defined in the POSH Act, internal complaints committee can punish. So if internal complaints committee convicts an employee, then that conviction will act as a disqualification from receiving bonus. A very interesting provision. Actually, this is introduced with an aim to make employees more cautious or prevent commission of this type of sexual harassment in workplace. Then, payment mode. As I said, in the older regime, bonus should be given in cash. The payment can be made only in cash. But when it comes to new code, it can be done or it should be made through bank account. That is, digital payment is made. Then regarding the penalty, there was a change. Earlier, in our old Payment of Bonus Act, for violation of the provisions of the Act, imprisonment was prescribed. That is, imprisonment up to 6 months and a fine up to 2 lakhs. But when it comes to new legislation, for most of the violations, monetary penalty is being provided. And very in rare occasion, imprisonment is provided. That too in case of a repetition. And fine will go up to 1 lakh. So there is a reduction in the penalties for violation of the provisions relating to bonus. Now, let me tell you briefly about customary bonus. In a country like India, in different parts, we are celebrating many festivals. So during festival season, obviously, we are supposed to spend more money. So what these employers will do, they will provide a festival allowance. And that festival allowance is considered as customary bonus. Now, there are many disputes also regarding this. So those who are teaching bonus related law, you might be knowing this extra payment during festival season as a practice or as a customary practice, sometimes it will lead to dispute. So always a question arises, what can be considered as a customary bonus? Whether all type of extra payment can be considered as customary bonus. So customary bonus is nothing. It is a payment traditionally being given in connection with some festival or some social change. Now, there are many cases. Through those cases, the judiciary has identified certain criteria to determine whether a payment of bonus is customary in nature or not, or whether it is a customary bonus or not. For your information, let me tell you the first ingredient is duration of payment. How long this practice is being done, whether it is a very long practice or it was started just a few years back. So that is one of the very important criteria. And the law says, or the judicial decision says, minimum 3 years, continuous practice of minimum 3 years. Then consistency. Suppose if you are saying for the last 10 years or 15 years, we are receiving bonus during Durga Puja, then the question is whether all these 15 years you have received this without any break, without any break or without any change. So if you have received uniformly all the last 15 years, we can say there is a consistent payment of bonus. Then unconditional pay. It should be unconditional. There should not be any promise or any agreement or any subsequent criteria to be met. Like if we achieve this much target or this much profit, we will give nothing like that. It should be an unconditional payment only based on the occasion of that particular festival. As a voluntary nature, the employer is giving. Now, if all these three things are satisfied, the fourth criteria, if these three things are satisfied for the long, it was a long practice, automatically employees can expect in the next Puja day also or Puja festival also, we will get the bonus. That reasonable expectation also should be there. So if these four criteria are satisfied, a payment of bonus can be treated as a customary payment of bonus. So just read the relevant literature if you want to know more about this. All these criteria were established through many cases. There are a large number of cases which discusses what should constitute customary bonus. Now let us discuss some challenges. As I said, the legislation was enacted in 1965, and even from 1950 onwards, we have a formula. Then subsequently, legislation came, and many amendments were done in the Payment of Bonus Act in order to make it more effective and to avoid or reduce conflicts. And to an extent, the Payment of Bonus Act was successful and it continued till 2019 or in fact 2025. Even now it is continuing, but theoretically till 2025 November it was continued. Now from 2025 November onwards, new wage code taken into operation. Now when this new code came into picture, it poses many challenges in the statutory entitlement of wages. So I have seen many literature where severe criticism is leveled and some are appreciating, some are taking a midway. So in my discussion, I will point out some of the major criticisms leveled by different authors against the new provisions under the code. So first major problem is ambiguity regarding the definition. Now, this ambiguity, if you look at old regime, our industrial and labor laws, based on the specific sector or specific establishments, we have a very effective definition for wage. So that is why we have found multiple definition for wage. And that was considered as something good at that time. The reason is every sector having some difference or some uniqueness. So if you apply same definition everywhere, that may create some problem. So when the wage code introduced a unified definition for wage, it creates problem. Especially if you look at the definition, this definition includes basic pay, DA, and other allowances. But it excludes house rent allowances, overtime allowances, and bonus, etc. And there is a mixed reaction against this exclusion and inclusion. Many are arguing that this is not correct. These exclusions are not correct. If these exclusions are allowed, that will affect the amount of statutory bonus. So that is what one of the ambiguity or one of the severe criticism I could find in connection with our new provision. Then second is inclusion of variable pay, another criticism. Now, the new definition includes variable pay components such as incentives and commissions. And these variable pay components like incentives and commissions, they were not considered as or they were excluded from calculating statutory bonus in our older regime. And if you look at the case laws, the disputes, or employees' demand at that time, they were happy with this exclusion. Now, the new wage code includes this variable pay components, and that inclusion will adversely affect calculation of statutory bonus, especially with respect to those employees who receives a variable pay. So that is another major criticism I have found. Then exclusion of certain allowances, specifically excludes certain allowances. And as I said, excluding these type of allowances, some of the allowances were included in the older regime and now it is excluded. Then that will affect the determination of bonus amount. So that is again another criticism. Then regarding the eligibility, there were many criticisms. And as of now, one of the criticism is the salary ceiling. Now it can be overcome or it can be removed at any time by the government through introducing a proper salary ceiling. In fact, it was there in the old regime as 21,000. And the 21,000 came after many discussion and after the amendment. So since we are again, the society is changing, any amount more than this 21,000 may be considered as a good amount for determining the wage for determination of statutory bonus and the eligibility. Then minimum period of service, that is again a problem. Minimum period of work was 30 days. At a time in an employment, the employee has to work in 30 days. Now the problem is this requirement, again, it has to be left with the discretion of the appropriate government. If the appropriate government prescribes a different period or different minimum period, it will lead to uncertainty. It will lead to inconsistency. So that possibility is there. But let us see how the appropriate governments will think in different sector. Because based on the law, based on the existing legal framework, appropriate government will vary with respect to different establishments and institutions. So when you are giving discretion to appropriate government, and we know in our country, every state having their own economic condition, economic policy, industrial policy, labor policy, etc. So they may follow a what we can say uneven or inconsistent mechanism. So that will again another problem which is being cited by many authors. Then coverage of contract workers. This is something which is a well appreciated movement in the new wage code. In fact, the contract workers were covered, as well as those employees, they were considered as not regular. They were also covered under this code on wages. Now, the problem is earlier they were not eligible for bonus because they were not covered under the Bonus Act. Once the law says these type of or these class of employees will come under wage code, the question is how we will determine the bonus, statutory bonus. As of now, we don't have a framework dealing with determination of their eligibility as well as determining their statutory bonus. So that is going to be one of the very, very strong challenge in implementing these provisions. Another similar challenge is regarding the gig workers. Now, including gig workers within the code on social security. That was a very well appreciated movement because a large number of people working in this sector will get the benefit. But the act, our wage code is silent whether they are entitled for bonus or not. Now the problem is bonus is considered as a social security component. Now social security code includes or covers gig workers. Automatically a question arises whether bonus is also extended to them. If you read our provisions relating to bonus, we will not get an answer. So it is silent about inclusion of gig workers. If at all the benefit of statutory bonus has to be extended to them, how to extend it? That creates a challenge. So that is another serious challenge. Then coverage. If you look at unrecognized sector workers, again, our social security code is much appreciated on the fact that it extends coverage to unorganized sectors. It's a very good movement, no doubt in that. But the problem is, are they eligible for statutory bonus? Now, if they are eligible for statutory bonus, how it will be really implemented? Very difficult task. So that will be another challenge. Then portability of benefit. This is another challenge. Now, earlier, when you shift from one place to another, usually we will close down our benefits in that employment, and then we will go to the new place, and we will restart from beginning. But here, the new social security code allows an employee to carry forward or port whatever benefits are there in one employer to the new employer. Now the problem is the portability or transfer of bonus and related things is very difficult. The reason is we don't have a specific rule or law dealing with how to do or how to go for this portability and how to facilitate this portability. So this portability may create a trouble. Especially you take the case of unorganized sector or gig workers or contract labor, etc. It will be a very tedious process. Employers will be very reluctant to do all these things. So that will really pose a challenge in the implementation level. So these were the challenges I could find. And to my reading, what I would say, the new code is not something which can be criticized severely. Though there are many authors, many literature I read which criticize very in detail, but I would say these criticisms are all temporary in nature. The reason is the appropriate government is vested with the powers. Once the appropriate government exercises those powers as per the provisions and introduces the required rules and regulations, I am sure most of this criticism will go and most of these apprehensions will vanish. So, to my understanding, these provisions are very good movement and it will definitely provide more protection to the payment of statutory bonus, not only to the employees who were eligible prior to the introduction of this code, but to the new employees like gig workers, platform workers, contract laborers, any other unorganized sector workers. So, with this, I would like to conclude. And if you have any doubts or you need any clarification, we have time, we will discuss. Thank you.
Yes. Thank you, sir, for your insightful presentation on the statutory bonus under new labor codes. Dear participants, now the session is open for discussion. If you have any questions, any clarifications, any observation, you can ask the resource persons.
Sir,
Please.
hello.
Please.
Okay. Sir, the gig workers will not be eligible for bonus since there is no traditional employee-employer relationship. Gig workers will not be eligible for bonus. And like the portability of bonus will not be coming. Portability will be coming in the welfare act measures under social security benefit, like building and other construction workers board, unorganized sector workers board that we have to constitute in newly. So
Okay.
in these cases, portability will be applicable.
Yeah, see, regarding this gig worker, what is the issue is, see, bonus is sometimes, not only sometimes, it is generally considered as a social security measure. Right. Now, once they included under the code on social security, how we can exempt or how we can disqualify them from receiving bonus? This is the issue.
No, sir. Government is planning something else for the gig platform workers.
Yeah, let us see that. That's what I said. All these criticisms are temporary in nature. Once the appropriate government takes the role while framing the rules or regulations, all these apprehensions will be vanished. So let's wait for some time. We can expect government will do something good. Any other query?
Jay sir, I think there is no queries as it is a very clear discussion on the wages, sir. Sorry,
Sir,
bonus.
there is a
Yeah,
question.
there is a question now.
Questions in
Yes.
the chat box.
Yes, sir.
Yes. What are the grievance redressal
What is the
mechanism
question?
yes, sir. What are the grievance redressal mechanism regarding to bonus under India's new labor codes?
Okay, see, there is no separate mechanism as such. Earlier also we don't have a separate mechanism. We were following our industrial tribunal. So same mechanism will continue. There won't be any change. There is no special body or anything. It will be just like our industrial disputes code on industrial disputes. So same way it will continue. That bodies will be taken care of. Clear?
Yes, any other questions? Yes, shall I conclude? Yes.
You can ask.
Thank you, sir. May I now request Srimati Pratibha B, Assistant Professor, Vivekananda College of Law, Bangalore, to propose vote of thanks.
Yes, sir. A very good evening to one and all. At the outset, on behalf of Vivekananda College of Law, it is my absolute privilege to propose the vote of thanks for this highly insightful session on statutory bonus under India's new labor codes, key changes and emerging challenges. I extend my deepest gratitude to our eminent resource person, Dr. Avinash V. Pillai, Associate Professor, School of Legal Studies, Cochin University of Science and Technology, Kochi. Sir, your profound expertise and clear articulation of shifting paradigm in statutory bonus regulations, along with the navigating and emerging legal challenges, have immensely enriched our understanding. We are truly grateful to you for sharing your profound expertise and insights with all of us. Thank you, sir.
Thank you so much. Thank you so much.
Okay, sir. I owe a tremendous debt of gratitude to our respected principal, Professor K.B. Kempegoda, sir, for his visionary leadership and for institutionalizing this FDP as a biannual benchmark of academic excellence. Your commitment to organizing this program ensures that our academic fraternity remains continuously updated and empowered. Thank you, sir. I express my heartfelt thanks to our program coordinator, Dr. Vijay, for his untiring efforts in ensuring the flawless conduct of this program. Thank you, sir. And I also thank the IKC coordinator, Dr. Bhuneshwari Eskolki, for her constant and unwavering support, which serves as the backbone in ensuring the smooth functioning of this entire program. Thank you, madam. Finally, I extend my sincere appreciation to our participants, including principals from various colleges, and my dear colleagues for your active participation and thoughtful questions that has truly made this program a grand success. Thank you. Thank you, everyone. Have a
Thank
good
you.
evening. Thank you.
Just one sentence. In fact, this
Yes, sir.
topic we used to discuss at least 1 month in class.
Yes, sir. Yes, sir.
That's true. That's true, sir.
That's
Yes,
what
sir.
teaching level, you know very well. We used to discuss, we used to take 1 month for discussing this entire bonus.
Bonus. Yes.
Now
sir.
I got only 60 minutes to cover entire thing. Anyway, I hope participants got some information regarding the new changes and challenges. Thank you.
But
Thank you.
it's an excellent presentation, sir. Thank you
Thank
so much for taking an
Thank you.
effort to make it so informative and excellent. Thank you so much, sir. Thank you
Thank
for
you.
accepting our invitation. Thank
Thank
you, sir. Thank you. So, shall we end the session, Vijay, sir?
Yes, madam. Yes, madam.
Yes. Thank-
Madam, that feedback form link is not yet provided.
Yes, sir. It's already provided, sir, in the group, in the
Okay.
chat
Madam,
group. In the chat
Madam,
box,
please,
it is provided.
please tell the resource person for tomorrow and the topic, please.
Yes, Vijay, sir.
Yes, madam. Yes, dear participant, we are pleased to inform you that the session scheduled tomorrow will be delivered by Sri K.G. Johnson. He will be discussing on restructuring the labor administration for effective implementation of the labor codes. Thank you.
Participants, you can see in the chat box, we have provided the link to share the feedback. So please fill the feedback form. Vishak, sir, did you get it?
Yes, I got it. Thank
Yes,
you.
yes, sir, yes, sir. Vijay, sir, end madada?
Madam, end ಮಾಡಿ.
Thank you.